Hi guys, welcome back. How are you? Trust you're doing great. So today we are going to be talking about a very important topic that concerns everybody, practically everybody. And what are we talking about today? We are talking about divorce. Divorce. I know that most of us have heard the word divorce. What does divorce means? Divorce simply puts it the process of bringing a marriage contracted under the Act to an end. Statutory marriage. When we say marriage under the Act, I'm talking about statutory marriage. Statutory marriage, it's marriage, the one you go to court to do with your spouse, or marriage registry to do with your spouse. It's called statutory marriage. And to bring marriage to an end, it is not about you going to get divorce paper. Oh, come and sign, the marriage is over, I'm no longer interested, come and sign divorce paper, and all the things we see in Nollywood. No, divorce, it's not done that way. And what is the legal ground for divorce in Nigeria? The sole ground for divorce is that the marriage has broken down irretrievably. The marriage had broken down irretrievably. To prove this, the petitioner, that is the spouse initiating the divorce proceeding, the person initiating divorce proceeding, it's known as the petitioner, must establish some facts to show that the marriage has broken down irretrievably. And what are these facts? The first one is lack of consummation. The respondent has persistently and willfully refused to consummate the marriage. What do I mean by this? The respondent, the other spouse that they are bringing the divorce proceedings against, has consistently, persistently, willfully refused to have sex with the petitioner. The second one is adultery. The respondent, that's the other spouse, has committed adultery and the petitioner finds it intolerable. The petitioner cannot live with the spouse based on the intolerable behaviors. He has committed adultery. So, and the respondent has behaved so that the petitioner cannot reasonably be expected to live with him or her. Then another fact to be proved is 2 year separation, that the parties have been living apart or have lived apart for at least 2 years, and the respondent has no objection to the divorce. The next fact to prove is living apart for 3 years. Just like living apart for 2 years, that the parties have lived apart for a continuous period of at least 3 years, even if the respondent does not consent to the divorce. Failure to comply with the order of restitution of conjugal rights, that is another ground. The respondent has, for a period not less than 1 year, failed to comply with an order or a decree of restitution of conjugal rights made under the Act. Then the next one is presumption of death. Those are the facts that need to be proved that the marriage, those are the facts that can show that the marriage has broken down irretrievably. It's presumption of death, that the respondent has been absent from the petitioner for an extended period to presume that he is dead. I think it's about 7 years or thereabouts, if the other party has not seen the spouse and it's presume that, oh, for this period of years I've not seen you, so it's likely that the person has died. That's another fact to prove that the marriage has broken down irretrievably. So which court has jurisdiction over divorce matters in Nigeria? Divorce matters for a statutory marriage. When I'm talking of statutory marriage, I'm talking about marriage under the Matrimonial Causes Act, not traditional marriage. Which court has jurisdiction over statutory marriage, to divorce a statutory marriage, to bring a statutory marriage to an end? Divorce matters for a statutory marriage are filed in the High Court of the state where either of the spouse resides or where the marriage was celebrated. I'm going to run us through the process of instituting a divorce matter. How do we start the commencement of a divorce action? The first one is petition. The process begins with the petitioner filing a divorce petition at the appropriate high court. The petitioner outlines the ground and reason for the divorce and provides the details about the marriage, such as the names, the date of the marriage, family properties, and any children involved. While the next one is service of the petition. That is done by the court bailiff. The court bailiff serves the respondent, that's the other party, with the divorce petition and other relevant documents. Where the respondent cannot be served personally, he or she can be served by substituted means. That is either by pasting it at their door or email or his last known address, just as the court may order, depending on the circumstance of the case. The next one is answer and cross petition. The respondent can now file an answer to the petition, admitting or denying the allegations. The respondent can also file a cross petition if he or she wishes the court to rely on a separate reason to prove the ground for the divorce. The next step is compulsory conference, that is mediation. In some circumstances where children below the age of 18 and settlement of properties are involved, the parties must participate in a mandatory conference to find a middle ground, and where these parties cannot reach an agreement, the judge will decide on such matters. The next trial, if the respondent filed an action to the petition, parties will present evidence and witnesses may be called to testify. In circumstances where the respondent does not respond to the suit or file an answer, what happens? Only the petitioner will testify in that case, and the right of the respondent to testify will be foreclosed. He will no longer be allowed to respond. That right will be foreclosed. Then the next one is judgment. The court will assess the evidence and deliver a judgment. If the court is satisfied that the marriage has broken down irretrievably, the judge will grant a decree called decree nisi, that is a provisional divorce order. Then after the decree nisi, there will be another decree. The seventh step is decree absolute. After 90 days, this decree absolute is given. After 90 days, the petitioner can apply for a decree absolute or the final divorce order, officially divorcing the marriage, bringing the marriage to an end. And if the decree absolute is granted, the marriage comes to an end. It's not about, oh, come and sign divorce paper, I'm no longer interested in the marriage, I'm done with this marriage, I'm bringing divorce paper for you to